Okay, welcome everybody to our Monday Zoom and Learns. We hold these Zoom and Learns on a different topic every Monday at 12:30, and it is the same Zoom link each week. So we hope that you'll join us each week. We try and do what's top of mind or based on questions that come in throughout the weeks. We try and hold topics that are meaningful and that can add value to you. So my name is Tommy Dutcher. I'm the area sales manager for California Title. And my co-host and our speaker today, our trainer today, our woman with all the answers is Mary Jane Morris.
Hey everybody, I have lost all visual of you all. Sorry about that. Hold on.
That's that dual screen you use.
Yeah, darn. Everybody talked me into it too. So, hi everybody. I'm so glad to see you and be with you. Actually see you right now, but oh, hey, there we all are. I'm so blessed.
Hello. Sorry, I'm a little late.
Hey Tracy, hi, welcome. We were just getting started. So,
Oh, awesome.
yep, couldn't have picked a better time. Hi Tracy. Hi everyone. My name is Mary Jane. I'm the VP of Sales for Granite Escrow and for Riverside County. Alongside me is my partner in crime, Tommy Dutcher, as just introduced himself, and Tracy Hasse, our San Diego rep, and I'm sure our La Jolla rep will pop on. Sure, she's doing something important as well. So today I want to talk about liquidated damages and mediation and arbitration. I try to do this about once a year, regardless, because there, for lack of a better term, there's so much bullying out there when a contract fails. Everybody gets annoyed and upset and fearful. As you've heard me say in other classes, I really think that when people get nasty, it has a lot to do with fear. They aren't happy with the situation. They're not sure how to clear it up. They're not sure who's going to be kicking their butt for the deal falling out and that sort of thing. And the seller and the buyer doesn't necessarily have a clear understanding of when they can and cannot get the deposit. And it seems very cut and dry to them. But there's a lot of threatening going on between agents that we're going to take you to mediation, we're going to take your deposit, we're not going to release it, we're going to do that sort of thing. And in my previous existence as a broker, I got to the point where I could say very quickly and very easily, no, you won't be doing it, because we'll be, as long as it fits in the small claims court amount, we'll be taking it straight to small claims. So I'll have you, keep in mind that the whole world's kind of under COVID rules where courts are concerned. And while you can get a place in line in small claims right now, you can't get a date just yet. Probably will be the end of July or June before we see the end of that. I, on a separate note, have been hearing that there are no planning sessions to extend the tenant situation after the end of June. And so unless that changes sometime pretty soon, that wall is finally going to come down and the courts are going to be flooded, and there's going to be a lot of news stories and that sort of thing going on. So while it's a blessing for sure that we're going to have our courts open again, it will take a while to untangle it a little bit. But I wanted you to be really comfortable with what your rights are and where you are right and where you should talk to your broker and seek more counsel. Before I even get into liquidated damages, one of the things that many agents told me when a buyer fell out and they were annoyed with them, that they would not help any further that client, see them through getting their deposit back. They weren't going to talk to them anymore, that sort of thing. I just want to make that clear right from the very beginning that is not an option. Payment is not part of our fiduciary duty. It is a benefit of our fiduciary duty, but when we take on the responsibility of putting a deposit in escrow, we are going to be seeing it through. So just to clear that up right from the very beginning, you cannot just in a transaction or a client because you're disappointed. Now, somebody else may have to take over communication. Maybe your communication has failed and it's going to have to be the broker, the sales manager, or someone. But the idea that you could just abandon a client when they've got money in escrow is not correct either. And it's the fastest way to get yourself named in the small claims as well, because some of the craziest ones and the easiest ones I've seen in one area is when a buyer or seller not understanding will sue everybody they can think of, the home inspector, the agency, the broker, they will sue everybody. And so you wind up standing on what I call the wrong side of the courthouse. I don't want to be standing on the side that's defending. I want to be the side that's pursuing. So I'm going to teach you guys what your rights are and how to debate liquidated damages. So I'm gonna walk you through card slideshows on both of these. They're both pretty short, and then I'm gonna give you some conversation about it. We'll take some questions about it. But it is intended today to increase your confidence on when you're in danger of losing your deposit and when you're not, and what your options are to get it that do not include the often very expensive and time-consuming arbitration and mediation. One of which does not guarantee any results, and the second one is an expensive option that you could have gotten, where the binding arbitration you could have gotten in small claims court with an act of law for 1/10 of the cost. So it's we're going to talk about that real quick. Tommy, you mind bringing up liquidated damages slide for me?
Yeah.
And then I think this is their welcome slide. And then the next slide just talks about what the term means, liquidated damages. And then I'd like to go to, in the event the buyer breaches the contract. So one more slide. So one of the things that most people don't know about liquidated damages is that it is a pre-agreement that whatever that amount is that's on the EMD line and an increased deposit, if you happen to have gotten one, is a pre-arrangement. The seller cannot ask for more if the liquidated damages clause is signed. So when a buyer doesn't want to sign it because he thinks that he's giving away his deposit, he's actually protecting that it will not be more than the deposit. I want to talk about actual damages versus liquidated damages. This is why many of us who've been in the business a long time will notice that the further up you go in the education of people who are buying, the more education, frankly, the wealthier they are, the people who have attorneys handy, they will automatically not initial liquidated damages. And instinctively, especially when you're young in real estate, you might think that's foolish of them, that they're not going to get that liquidated damage because they didn't collect, they didn't initial it. What they did was they failed to limit it to the amount of the deposit. So they can now sue you for actual damages. This is a completely different thing than liquidated damages. So if you didn't know that, this class was worth it right there. Okay, liquidated damages is limited to what you put on page 1 of the RPA. So, and once it's initial and if it's not increased.
MJ,
yes,
there is a chat question that says, what happens if the buyer refuses to sign the liquidated damages form for the increased deposit?
Well, for the increased deposit, then the seller would give a notice to perform if they were insisting on it and wanting it to be liquidatable. Again, this is another thing that I discuss with people all the time. If you put the increased deposit on page 1 of the purchase agreement and you follow it up with the RID, the seller forces you to follow it up with the RID, that additional deposit is automatically included as part of liquidated damages. So the advice I give is twofold. One is a buyer's agent, don't ever increase your own deposit on page 1. Let them do it on page 2 and then hope they never do the RID and you will never be in the position of losing the additional amount that was agreed to. On the flip side, as a seller, if you increase the deposit, you need to follow up with that RID form when the time comes. I'm going to try to avoid talking too much about the new contract for those of you who are one of our regulars. And starting tomorrow, we will be advertising the rest of the week, your first look RPA class. We have a special event on Friday at 12:30 using this exact same link where we're going to go over the RPA. And I've thinned out the HARS version of it so that we can do it a little faster. But for today, liquidated damages and actual damages, I want to make sure you know the difference. Okay, so on the listing side, if you want to be able to claim more than, if you feel like your seller is the type of person who may want to charge for his mortgage payments that he made while he was, after they failed to close, or moving costs that they incurred, things that are outside the limit of the liquidated damages, then you need to be very careful that you understand which side of the transaction you're on. For a buyer, it's very important to look at initial liquidated damages because you're limiting it to that amount. They can't charge you anything more. On the seller side, it's in your best interest not to do it, but most people don't even know that. So it's like I said, there's a lot of misunderstandings that go between actual damages and liquidated damages. So are we clear? I hope we're clear on that. If we don't, by the way, recently we did start muting you, but feel free to just because we had a difficult subject a few weeks ago. But if you guys want to talk during the meeting, feel free to ask a question. Let's talk about the liquidated damages rule. Next slide, please. So liquidated damages, they must be a reasonable estimation of the time of contract. So the days of $500 VA deposits are long gone, I would think, and the $1,000 are pretty well gone. And certainly in this market, that if the person intends to occupy the property, it is fixed at 3%. But here's another thing enough people don't know. When an investor is coming in at you with cash, they are not limited to the 3%. You can take a $50,000 liquidatable deposit from a cash buyer. I think that we all have a pocket full of investors who can buy cash and we're very comfortable with that. But we've all been on the other side of it where they really didn't have the $3 million hand liquid that they had in their proof of funds. And we're waiting for another transaction to close, and it becomes. So I can't help but recommend that when you have an investor buyer that you get that deposit up high, and that you not take it as a owner occupied level, which is limited at 3%. They can take $50,000, whatever the amount is, over, and then they'll have to debate with you, negotiate with you to get it back. So I think I covered rule 3 as well. Residential 1 to 4, 3% is presumed valid. The provision must be, the liquidated damage rule must be signed and initialed, or it is presumed out. The law requires anything that's in any kind of contract that is going to be agreed to specially, that it must be in at least 10 point. They prefer it to be in red as well, and it must be for initialed separately. So that's another good rule to keep in the back of your mind when you are tightening up your contracts, writing a good counteroffer or something like that. If you want them to agree to something very, very specific, if you put it in a certain size print and have them initial that specifically, it does increase its, it takes away the fact that they can say they weren't informed or didn't read it or didn't understand it. So the number 6 is kind of confusing, but what it's saying is 1, 2, and 3 must apply, and then 4 or 5 had to, item 4 and 5 of this list had to be a factor for you to liquidate the damages. Next one. So for those of you that we're going to talk about 21B here, but for those of you who've never read 21A, there is no such thing as a non-refundable deposit in real estate. And when we write that in, it is not enforceable. So when a seller says, but I want that deposit no matter what after 5 days, there is no such thing as a non-refundable deposit. Now, there could be a pre-release deposit where a person may have rights to debate with you later to get it back. That's why escrow has to sign something that says they can't get it back for you, because because it will take an act of law or mutual agreement at that point. But there is no such thing as a non-refundable deposit in real estate, no matter which way you write it. So I wanted you guys to see 21A. So 21B reminds that of the rules we just went over. It says them in more legalese, and it says that they recommend the use of an RID form if you're going to increase the deposit, and you want that second amount to be liquidatable. So when you write in a counteroffer deposit to be $7,000 instead of $5,000, and you don't follow it up with the RID form and or the requirement, and then follow up with the form itself, the second amount that you've increased it to from what was on page 1 is not liquidatable. It's a very important point. If a buyer impresses you, especially in these markets right now, and wants to put down a lot of money, most of the down payment in as the earnest money deposit, the law does still limit owner occupied to 3%, and you do have to return the remainder of the deposit. So you can secure it with, I'm sorry, my cat is banging on the door. I'm gonna miss seeing kids and cats and all that when we are past our Zoom days. So if they accept more than 3,000, if they accept more than 3%, you have to return. You can't keep the whole deposit. And one of the ways that you can bring the temperature down is to go ahead and release everything over 3%. In certain circumstances, that will bring the argument back down to, because the person coming at you for 50,000 is going to be a very different mood than a person coming at you for $5,000. If 5,000 is all you can catch, no matter how much you took, it's okay to agree to release a portion of it. It's not an all or nothing proposition. I don't know if you guys are aware as well, this is just a little side note of mine, that when a deposit is liquidatable, the agent could argue and ask for up to 50% of it for commissions that were a loss. I have never seen a single person do this because we are all hoping to put them in another deal. The seller's already angry enough. Maybe I never see anybody do it, but the rule does say that if the seller is able to liquidate the damages, up to 50% could be claimed by the realtor for loss commission on that transaction. Okay, next one. The RID, the next one just talks about the use. Again, I just want to remind you of the third rule, that anything you increase from page 1 that you don't do the RID form on it, it's not going to be liquidated. Next slide, please. So this is a question a lot of the TCs ask as well. So when a person there's two ways this happens. Very often at the speed of what we're going, we counter, but we don't return the entire purchase agreement back. With the seller doesn't return, he just counters 5 people perhaps, and he doesn't return all 5 contracts to everybody. So previously it was known that if it was not initialed and returned with the counteroffer, it was also not agreed to. So CAR has come up with a best practice, which is that in your counteroffer, you should say that you want them to go back and initial in the purchase agreement. Strictly speaking, this includes redating, at least not as to the signature, but as to the initials where you are adding something. So just to head off the question of if we redate it, are we changing the acceptance? You're not, you're just doing a standard correction and dating the correction. The seller should return the purchase agreement with the counteroffer so the buyer knows if it's being initialed, and otherwise it is not accepted. They're doing little changes, and again, I'm going to try to avoid talking about the new contract, but your current counteroffer does say that if it's not initial, they're out. They're going to fix that in the next counter offer, but for now, and all the way till December, when the new forms become effective, if you counter only and you want liquidated damages or arbitration, and you didn't initial and send back not initial and send back the offer, then they're not accepted. They're not built into the agreement. Let's talk about what happens in disputes real quick. So I don't know how many of you have ever, when you log on to your zip forms, you have several libraries up at the top. So most of us are so used to just staying on the California Association of Realtors, we don't realize there's a lot of other libraries in there. You can buy libraries for other towns. The San Diego Risk Management Library is in there, which is, CAR has about 10, 20 documents that I have used my whole life, totally used to and like to use them. There's some really good extra stuff in there. But another library that is in there is your sample forms library. When I go through, every time I manage to wander over to the sample forms, the sample letters, I am once again impressed at how much is there that we don't look at. So if you are feeling like you have some time and you'd like to look at sample library letters. So there are sample letters in there, the buyer demand for return, the demand for the deposit, the contingency cancellation, there's forms in there. I think most of us who've been practicing for a long time know that no amount of form sharing guarantees the release of the deposit. There's only two things that will release a deposit. And this is one of my favorite managing expectations when I tell buyers at the beginning. There is only two ways for that deposit to be released from escrow. One is agreement. We've agreed, and that's how we're releasing it. The second is active law, and not another thing will release it. No person can go in, no person can demand, no person can show you a piece of paper and demand that something be released if it hasn't met one of those two obligations. So I mostly wanted to use this page as a pitch for the sample letters. There's so much good stuff in there. Very briefly and in parentheses, another good example of what's in the sample letters is a form that talks about when a seller fails to disclose. If you're dealing with a for sale by owner or a Zillow lead or an open door, those kinds of things, when they don't give you any disclosures, there is a form in there that says you were entitled to be disclosed, you were not disclosed, and we recommend you seek legal advice. Now, every time we say the words "we seek legal advice," I feel my agent stirring away from me because that's the last thing we want to advise them. We feel. Honestly, it's your go-to position in most of the time. So if you stay with your client and help the lawyer get the things and help their officer stuff, you have a much better case of staying on the right side of the courtroom when the time comes. So I want to encourage you to take a look at those sample letters. Some great sample letters in there. So another thing built into our purchase contract that we're used to is that if a seller or buyer simply refuses to release the deposit, to sign the cancellation and release the deposit, there is a penalty, a potential penalty of $1,000. Now, one of the classes that I have to teach you guys this summer sometime is a class I wrote called How to Win in Small Claims Court, and I have been hundreds of times now. Initially, as an escrow officer, we almost immediately get released, but we have to show up and listen for a while. So I have watched, and I do threaten people with the $1,000 penalty all the time, and I will bring it to the judge's attention. I've never seen it awarded. Most judges presume that if you're standing in small claims court, that you had a legitimate beef that you didn't understand, you couldn't come to an agreement, and they won't necessarily, it would take a very egregious act on the seller. However, I will say now, thinking out loud, that after all the COVID cancellations of the last year, it's potentially possible that the $1,000 could be awarded for refusing to release over a legitimate, provable COVID case, not just a COVID escape. that was not legitimate, but it is potentially possible that a seller refusing to release a deposit in a national emergency would be seen much different. And I might post it, I might argue that way myself if I was making the argument in small claims. Both of the letters that are in the sample letters meet the requirement. When you go to small claims court, you have to have demanded the money first. So after you had your back and forth, your agents have given up, the brokers have given up, and now somebody wants to file small claims. The very first thing for small claims is to demand the money and why. It is your first exhibit in a small claims court matter. You do have to demand your money and you have to say why. Now, this feels ridiculous in some cases because we feel like we've been demanding it for months, or why would we even be here? But a written demand letter is the first, and I always tell agents, get it out of the way now. Just go ahead and get it away now. It'll be documented 5-6 months ago when we finally get ourselves back into small claims. Let's talk one more slide, Tammy. So let's talk about, can escrow help? Well, yes, they tried to. That's including the revisions that we're getting shortly. The California Escrow Association is part of that group that sits and meets and decides. Now, because escrow had no way to release deposits when a person just disappeared, and people do occasionally just disappear, and they're not actually putting up a fight for the deposit, they're just not going to help you get it, and they make themselves scared. So they did come up with a form and write it into the contract that you can buyer demand to release the deposit, or the seller demand to release the deposit. And after 10 business days, if there has been no reply, the escrow company can unilaterally decide to return the deposit. I'm going to say 9 out of 10 won't do it. We know that the person who disappeared for a time may show back up, and they don't want to argue those claims. Tommy, do you happen to know California title policy on accepting buyer demands or seller demands? I know Granite Escrow cannot.
No, we would not as well.
On them at all. So you will have to find out.
I don't know anybody who would, be honest.
Yeah. Obviously, the escrow officer knows what's been going on, and if the seller is legitimate, but one of the parties is legitimately missing, the escrow officer is likely to know it as well as you are, and they can make an argument for releasing the deposit unilaterally, but it is very rare. My only advice to you is that when the time comes from, they made the form because there are occasionally situations, I'm getting a question in the chat, why did they even make the form? There was literally no hole in that contract that allowed escrow to drive through it ever. And there are sometimes legitimate times when, an example I had last year was by the time the seller listed her property, showed it, sold it, and was in escrow, her dementia had increased to the point where she began to speak gibberish, and nobody could take her word on anything anymore. But there was no setup for the release of her deposit. The only thing that the seller wanted was out of this escrow. You are selling my house against my will. On the advice of the escrow council and the real estate brokers council, they did decide to have this form signed, wait out the 10 days, and give the buyer back their deposit because the seller had become incapable, and the only thing they wanted was out of the transaction. And once the buyer was really tuned that up, all he wanted was his deposit back. And so this was an opportunity where, and by the way, that particular escrow company told us no at first. We waited it out. We discussed it. It finally went up their chain to the council. It had been 20, 30 days. The seller was definitely now hospitalized, not going to be available. And they made the decision that they would take the risk to release the deposit. So the answer to your question is previously there was no even a glimmer of hope that deposit could be released any other way. now there is at least a glimmer of hope. This last page just has all the samples of all the sample forms, a list of all the forms. All these PowerPoints are available to you on the legal Q&A page too. And I'm always happy to park them in the chat as well. You're welcome to them anytime. They're not mine personally. They come as part of being a car certified training. And they send them to me pretty often. The one that we have this week is a warning. This last is a warning about accepting offers with no contingencies whatsoever, and how very dangerous that is. That's where we've reached. That's what we've reached with the current market right now. Even in my career, to see property go 100,000, 50, 75, 100,000, you know, we're already hearing numbers where there's 200,000 over and that sort of thing. So I'm surprised by that as well. So
we put the quick handouts, the quick guide handouts for both slideshows today. I put them twice in the chat. So if you guys go to the chat, there's a couple PDFs there you can download and save them to your computer so you can go back to them later.
So now I'm going to switch gears and I've merged these classes together, and we're going to look at the PowerPoint for the mediation and arbitration. So nobody can agree. We can't agree. And this is where the uninformed agent immediately day one may tell you that you're going to mediation or arbitration. That we will hold up your deposit until we go to mediation and arbitration and all that. As long as the deposit is less than the amount of small claims, you are not obligated to do mediation or arbitration. It is one of the arrows in my quiver that drives successful releases of deposits most often. 99% of agents think mediation and arbitration are absolutely have to before you can go to small claims. It is not required to do before you, if it fits in a small claims court matter. Now, that means at this time, $10,000 for individuals, but if you are dealing with an LLC or a corporation of any sort, you're limited to $5,000 at this time. I always thought that was a little backwards. It should be higher for the corporations, not less, but they do have some protection from being a corporation. You can, maybe that's their ideas, that it will limit the amount of these types of disputes and keep them to individuals. All right, so these next few slides go pretty quick just because they made them really clear. A mediator is just a neutral person who sits down and tries to talk sense to everybody. They try to say, Tommy, you have done a really great job, and Betsy, you've been a wonderful agent as well, and I know you guys didn't mean to get here, so what can we do to fix this? This is usually where everything that everyone's been saying that caused us to be here in the first place just gets said at high speed and with annoyance, and now we're facing each other. Another reason that I smile when other states do roundtable closings, it's hard for me to imagine getting everybody in the room at the end of a transaction and having the seller sitting there writing checks instead of the escrow person doing it. No, it's completely done. Understand it's completely legitimate, but so this may be the first time all these parties have sat down together is with a mediator. So they're hoping, and they use a lot of conciliatory language. If you're already kind of ticked off and they're saying things to you like, we really need you to think about another solution, it may take you off further. So the next slide. The parties to only the two parties who are mediating, and those are buyers and sellers. And most of the time you are not, your broker and your attorney, your broker's attorney is going to recommend that you attend either one of these. You are not a party to this transaction. You are only including yourself in the records as maybe slipping and saying the wrong thing. So it is not recommended that you, in fact, some days, and this is for me as well, you absolutely have to sit on your hands to keep yourself from wanting to drive over there and listen to what everybody's saying because you're so involved in that point. But for agents, you really do need to stay out of mediation. And at this point, we're a few months down the road, everybody's super annoyed, and and there's no commission coming out of this. So I would have to go with if I were your broker today, I would say do not attend either one of these. So next slide. Did I somehow get out of order? Okay. If mediation fails to settle, the parties can now go to arbitration, and the arbitrator final decision. Now, an arbitrator is a person that has at least 5 years experience in this area, has, you know, a background, probably a lawyer, most likely going to be a lawyer, or somebody who has very high mediation type skills. But now you're allowing a third party to make a choice who isn't a judge. So if it fits in small claims, I can't help recommend that you have an obligation to mediate. If you're going to sue for more than the small claims, you do have to mediate, and you will be forced into arbitration. Yeah, I mean, you have to mediate, but you do not have to arbitrate. At that point, you can take it out to a regular lawsuit. The reason it's in your best interest to mediate is that the person, if you fail to show up for mediation and you lose the case later, you get to pick up the attorney's fees for both parties. So it's pretty important that you show up. It is intended to get you to show up. Next slide. An arbitrator is like a judge. I prefer a real judge, but arbitration certainly can work. Just like one of the things I tell people in my small claims class is, once you put it in the third party's hands, I have no idea what the results are going to be. I tell a funny story that I had to sue somebody for the return of some business equipment. It was another lady, and she had discontinued communication with me, and I finally had to bring her small claims. And the judge had later said something very sexist. He said, "I'm going to do for you women what women cannot do for themselves. I'm going to come up with an answer." Every woman in the courtroom, including his clerk's mouth, dropped open because it was such a sexist comment. But I was winning. So I stood there and said it and said nothing. Had I been losing, I would have brought that to their immediate attention and tried to go up the chain a little bit. So anytime you put it in a third party's hands, you are in danger of getting a solution that you guys didn't come up with on your own. So negotiation is always a better solution. Next slide, please. When you're in arbitration, you're not getting a judge, you're not getting a jury, and you can't appeal. It's over. Small claims, you can appeal if you're on the losing side one time. So it's a bet if you're the person filing, not if you're the person who lost. So next slide. Arbitrations are private, and the parties choose the arbitrator. I am shocked what arbitrators get in fees. It's roughly going to cost you about $500 a person to set up either arbitration and mediation, and then you're going to get attorney fee level hourly rate, so $250 to $500 an hour. When you could have for $150, including service, take them to small claims court, as long as it fits in the small claims law. Now, another good question really quick. So what if your deposit is $12,000 that you're trying to get, but $10,000 is the limit in small claims court? One of the first things I tell you is just discount it back to 10 and make a point to the judge that you've already discounted it for it to be heard in this venue. Often this gives you points that you were willing to review. So if it's an amount that you can get back to $10,000, even if it's slightly above, the recommendation is to file for the $10,000 and note for the judge that you have already reduced this claim so it could be heard in this particular venue. Next slide. So I wanted you guys to see that you are required to mediate. You're not required to arbitrate, but you are required to mediate unless it fits in small claims court. This is where 99% of agents who are yelling at me when I was a broker telling me that they're taking this, there, and the other, I would say, no, you're not. You're going to be in small claims court in 30 days. And very often, because I have that wisdom, I would include the agent in that small claims. I want them standing on the other side of the court and to be in danger. And in some cases, you're going to sue them individually. You're going to sue the seller in one small claim. You're going to sue the agent in the other, depending on their actions. So you do have to mediate, but you, and then, by the way, if you read the last, nearly the last sentence there that's in all caps, whether or not arbitration below has been initial, mediation is a requirement of this contract. Next slide, please. Here's your arbitration clause. I went ahead and looked it up. For some reason, CARD didn't include the exclusions, which is paragraph 22. C, and it does say specifically that if small claims, unlawful detainer, bankruptcy, if it can be heard legitimately by another court, those are the exclusions to liquidated damages and arbitration. So again, it's not recommended as an agent that you go to these and that you're not required to arbitrate at all if it would fill, if it's a small claims. So the next one. Next slide. Thank you.
Getting it. Thank you.
So it comes down to, should I arbitrate decision? You know, you balance the scales and then you decide. Now, if it fits, if it's outside of the amount, if it's $1 million+ sale and it's really outside of the small claims, you are going to have to walk this line. You are going to have to go to mediation. And then decide whether your attorney is going to take over and go straight to a lawsuit, which you are entitled to do, or if you think there's some value that having somebody sit down and work and just decide for you. So we do have to have a method other than the courts to handle, to police our own agents and our own work, and that's where arbitration comes in. But it is not a cheap, and it is not any more of a guarantee than one of the things an arbitrator said to me in arbitration when I was doing probably 10 years ago. The buyer had done no inspections whatsoever for a commercial piece of property, and he wound up putting a business on there that wasn't allowed to be there, and he was blaming the seller and was demanding a reversal of the sale of $50,000-$75,000. And when I pointed out that he had waived his right to inspect, his right to repairs, and his right to walk through, had done no work whatsoever to see if the business he wanted to put there could go there, the arbitrator made a really unneutral comment about, well, what if there were bodies buried there? Would I not have any right to talk to you about it at all? You know, well, yeah, there weren't bodies buried there. That's not what we're talking about. So you will occasionally get somebody. I would rather have a judge. Another thing you should know about small claims is the small claims is almost always done by a, what do they call it, a commissioner. However, if you feel it's important enough, you can ask for a judge. Now, if you're going to small claims, you're going to be there all day anyway, because the people who are arguing, the people who aren't arguing, the people who successfully, who didn't show up or who are able to agree, go first, boom, 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 plus anything that was left over from the day before. So you are for sure going to lunch and coming back before they ever get to you in small claims. So it's important that you realize that once you go to small claims, you're going to be there the entire day, and sitting across from them most of the day as well. Because small claims does now, before they let you appear, force you into another mediation room where somebody else again tries to say, is there any hope of settlement here before we all waste the day here in court? So whether you want to arbitrate. And then finally, way back in the back, they put the one more slide for me.
Yep.
And finally, no requirement to mediate or arbitrate if the small claims is $10,000, if it can be fit into a $10,000 $10,000 claim. So, and then there's some resources for you as always. Like I said, I like to go over this about once a year. I hate when one of the most common calls I get is he won't release my deposit. And then we have to walk through this anyway. So I want you to know where your rights are and when you were forced to mediate and when you aren't forced to mediate and how can you take them to small claims instead. Prior to COVID with service, I was going to be looking at you across the courtroom in less than 45 days. That's the kind of action a buyer wants when he wants his deposit back.
And let's reiterate too, is, you know, MJ has many years of experience with this as a broker, et cetera. And mediation, arbitration, small claims is not the first, you know, jump to solution, right? If you were to call MJ in regards to, hey, this is a situation, they're not releasing deposit, she's probably going to have a handful of questions to ask of, first and foremost, how can it be resolved without those three options, right? I mean, nobody wants to go through the process unless you truly have to. You know, and it sounds, you know, she can get very passionate and you can hear it in her voice because she's been very successful in learning the ins and outs and, you know, how different scenarios play out. But you got to remember too, is she has a lot of experience, a lot of years. She also managed a broker or brokerage, I should say, not a broker. She was a broker that managed a brokerage that did hundreds of transactions a month as well. And when you do that kind of business, it's kind of inevitable. There's a small percentage where you're going to have issues arise, right? And, you know, first and foremost is how can we help you guys get out of just a bad situation that is taking place? A lot of times it comes down to just poor communication on one side to the other, or somebody not feeling like they're getting what they're entitled to, or whatever it may be, right? I'll be honest, a lot of times I direct agents to those letters because there are a lot of letters. If you were to ever call into legal and car legal, they'll probably direct you to a specific letter for your specific situation. And you send that. And a lot of times it changes the tune to either that buyer or seller, right? Sellers refusing to close on time because whatever, right? I'm sorry, you don't have that option. As long as the buyer's performing, you're contractually obligated to close on time. There's a letter for that. And it basically just outlines what their obligation can be if they don't, right? And sometimes these letters change the tune of the individual that's holding up what you need to be done. And sometimes they don't. Sometimes there's just no way of working around it. And you really don't have an option because both sides can't see eye to eye. And that's the next, you know, step. But you obviously want to try and work around having to go to arbitration or to small claims as much as possible, right? There's usually a solution. And that small percentage where there's not, unfortunately, you have to deal with those types.
I wanted you just to have the rules at your fingertips because, you know, there's a joke we have out there about the big book of made up rules that is agent will zing at you when they think they know what the situation is. So the two things I use the most often is confidence in that I know what I'm doing as far as the rules are concerned, and then courtesy. No matter what they say to me, I'm validating, I'm helping them save face, I'm taking notes. I have no idea what they're going to blurt out to me. So interrupting them and sometimes they will just get it, they will just have enough confidence that somebody heard them well, that they will finally start breaking down and make a decision. Whereas up till that moment, they felt that nobody was listening. So a lot of times, so in fact, not to beat a dead horse, but one of the things I tell agents all the time, when you have to write something difficult to anyone or have to speak it, the more courtesy, the more likely it is that you're going to. But every day in my business, I have to expect that somebody's going to come with a problem that they don't understand and a handful of hurt to go with it. So it's important that if you can, but mostly I don't want you to be threatened. I want you to feel very confident about you can and cannot do about it, the release of the deposit. Starting from you can't walk away, all the way to where you want out, and it needs to go, it's going to need to be bigger and more than you or your broker can solve. But most of the time, in fact, they tell, even before I was a broker, 99% of canceled deals do eventually release the deposit. So even if it's months down the road. So a final thought for you is when a buyer comes to the conclusion that cancellation is for real, and it is, and even if he's entitled to his deposit back, he's entitled to his deposit back, that he understands that it may take a little while.
Yeah. All right, well, we've opened it up for any questions. If anybody has any specifics or questions that they want to throw out, we're more than happy to answer those. I did put 2 quick guides for liquidating liquidated damages and mediation versus arbitration in the chat, so you can download those. If you guys would like a copy of the slide decks that we presented today, reach out to one of us and we can send those to you as well. I also put a link to where all of our Zoom and Learns are housed on a YouTube channel. So you can click on that and you can subscribe to get updates on our Zoom and Learns if you missed one, or if you want to go back and go through some of those based on what's happening in your business, you can. And one last announcement is this Friday, right? Yeah, this Friday.
Yep.
We will be having a special Zoom and Learn at 12:30, the same link. We will be going over the new RPA that will be launching. If you didn't get a chance to jump on CAR's Zoom that they had about, I don't know, 3 weeks ago, it was about 2.5 hours long. We've narrowed that down to give you all the data you need on the upcoming RPA changes, which is a complete revamp of the RPA, not just small little tweaks. We will be holding that this Friday, 12:30, same Zoom link, and we've narrowed it down to about an hour and a half. So please prepare for about an hour and a half of your time if you plan on joining us for that, which I hope you do. And we will answer, you know, those of you who don't know, Mary Jane is a certified CAR trainer. So she gets to go through the trainings with CAR and stuff like that in advance, which she has done. And she has put together a condensed version of what CAR presented to the agents about 3 weeks ago. So again, if you missed that, you will not want to miss this upcoming Friday Zoom and Learn at 12:30. Did I miss something? Nope. For everybody else, we will stay on. We're the last 2 to drop off. So if you have specific questions pertaining to your business or pertaining to what you learned today, we will stay on and we'd be more than happy to chat with you one-on-one. All right. So I hope to see you all Friday at the RPA. What are we calling that?
First look.
First look. The RPA first look. And again, that will be at 12:30. So hope to see you all then.